Hello, and welcome back to Off the Deaton Path. I'm your host, Stan Deaton with the Georgia Historical Society, and we welcome you to this podcast for the week of March 13th, 2025. We are coming to you this week from the Judicial Review Division here at the Georgia Historical Society on the 15th floor of the Jepson House overlooking beautiful Forsyth Park in downtown Savannah. My very special guest this week is author and law professor Stuart Banner, who joins me to talk about his new book on the history of the United States Supreme Court. Stuart Banner is Norman Abrams Distinguished Professor of Law at the University of California, Los Angeles, UCLA, where he has taught since 2001. He teaches property, the Supreme Court Clinic, and a variety of other courses. He holds a BA from Yale and graduated from Stanford Law School, where he was articles editor of the Stanford Law Review. He clerked for Judge Alex Kozinski of the U.S. Court of Appeals for the Ninth Circuit and Justice Sandra Day O'Connor of the U.S. Supreme Court. He practiced law at Davis Polk and Wardwell and at the Office of the Appellate Defender, both in New York. Before coming to UCLA, he taught at Washington University in St. Louis. Stuart is a legal historian who has written about a wide range of topics in American and British legal history. His books include The Decline of Natural Law, How American Lawyers Once Used Natural Law and Why They Stopped, published by Oxford University Press in 2021. Speculation, A History of the Fine Line Between Gambling and Investing, published by Oxford in 2017. The Baseball Trust, A History of Baseball's Antitrust Exemption, published by Oxford in 2013. American Property, A History of How, Why, and What We Own, published by Harvard University Press in 2011. Who Owns the Sky? The Struggle to Control Airspace from the Wright Brothers On, published by Harvard in 2008. Possessing the Pacific, Land, Settlers, and Indigenous People from Australia to Alaska, published by Harvard in 2007. How the Indians Lost Their Land, Law and Power on the Frontier, published by Harvard in 2005. The Death Penalty, An American History, published by Harvard in 2002, and his latest book, and the one he is here to talk with me about today, entitled The Most Powerful Court in the World, A History of the Supreme Court of the United States, published by Oxford University Press on November 4th, 2024. It was reviewed by the Wall Street Journal on December 6th, which called it thorough, nuanced, even-handed, and above all, eminently readable, which it certainly is. It is a very good book about a very timely subject. My conversation with Stuart Banner begins now. Stuart Banner, welcome to our podcast.
Well, thanks for having me.
You have written a history of the Supreme Court called The Most Powerful Court in the World. It is encyclopedic. It is fascinating to read for anyone who has a casual interest or a deep interest in the Supreme Court. It is absolutely the book to read. How did you decide to take on such a mammoth topic?
Well, I've been, for many years, I've been sort of kind of hovering around the Supreme Court as a lawyer and as a law professor, and then very, very early in my career as a law clerk. And so, I've always had an interest in it. And, people sometimes would ask me to recommend a good one-volume history of the court, and I always had a little trouble, And so I thought there was an opportunity there to write a book, Just if you want to hear more about that,
Sure.
there are books about the history of the Supreme Court. Most of them are they're just summaries of the court's important decisions. And so I wanted to write a book that, of course, would be about the decisions, but would also be a history of the court itself, a history of the sorts of people who become justices and how they're selected, history of what work at the court is actually like, what the people there do all day, that sort of thing. And then also, most histories of the court are really, they're written by people who, they have a political slant to them. They want to praise the court or criticize it. And I thought it would be much more interesting just to write a book. Well, I mean, the kind of books that I like to read are not books like that, but I thought it'd be more interesting to write a book that would be just a neutral book that rather than trying to say whether this case was decided rightly or wrongly, try to see things through the justice's eyes to try to explain why cases were decided the way they were.
And I think you succeed admirably in that. Did you have any connection with anybody at the Supreme Court while you were writing this?
Oh, while I was writing it, no, 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 no. I mean, um, I some people sometimes would ask me, are you going to interview any of the current justices? And
Hmm.
I said, well, no, absolutely not, because there's absolutely nothing that they would be able to tell me that would be at all, that would be something that people don't already know. There's,
Hmm.
if there's
Hmm.
anything, if there's anything confidential, they're certainly not going to tell me.
Right, right. And so but I have to believe, one likes to believe that sitting Supreme Court justices are interested in history. And did you, I'm sure I would like to think they're going to read this book.
Well, I mean, that would be nice. I hope so. I think that a lot of them are interested in history. In fact, some of none of not the current justices, but some justices in the past have actually written books about the history of the court.
Hmm. Hmm.
William Rehnquist, who was Chief Justice for a long time, he wrote several books about the history of the court. And a lot of the cases involve history. Often when they're interpreting what the Constitution means, they're interested in how the Constitution was written and ratified, and what various terms meant in the 18th and 19th century. So yeah, I think they are interested in history.
Hmm. One of the things you make clear in this book uh, is you begin at the beginning is that the court has always been. We live in an age now where we think the court is just full of political hacks. Whoever's got the winning side, we can just guess. We know exactly what they're going to do. You make it clear that the court has always been political. It has always been seen as political by those who were appointing and those who were following court decisions very closely. They've always played. There's been always been some with one eye on public opinion, so to speak. But still, the court has really changed over 200 plus years. And so I'll start at the beginning. There were originally six justices. There are nine now. One of the political footballs that's kicked back and forth a lot is expanding the court to suit a particular ideological viewpoint. How did the court get from six to nine? And that's a big question. I know that's not a short answer, but the point is that the number has changed through the years.
That's right. It started with six, and the reason for six was that in the early years, Supreme Court justices spent most of their time not actually sitting as Supreme Court justices, but riding around the country conducting trials as circuit justices. And then when the country was founded, there were three circuits and two justices per circuit, and so they needed six justices. And then as the country got bigger, the court expanded because they eventually would move to one justice per circuit, with six circuits and one justice per circuit. But then as the new states joined the union in the early 1800s, a seventh circuit was created. So they expanded the court from six to seven justices, and then two more circuits were created. So they expanded the court from seven justices to nine justices. And then there was when California became a state, that the California and Oregon became the 10th Circuit, and so that got up to 10 justices. So actually, during the Civil War, there were 10 justices. But then and so that was all done. It was not done for political reasons. It was done just because the country was getting bigger. Although the timing of it was very political, because the only time periods where you could actually expand the court were when the president and both houses of Congress were controlled by the same party, because otherwise neither side would want to expand the court to give appointments to the president of the other party. So in any event, not it
Mhm.
got 10 justices, but then after the Civil War, during Reconstruction, there was a lot of conflict between Congress and Andrew Johnson, who was the president. And so, in order to prevent Johnson from appointing new justices, Congress reduced the size of the court by attrition, from 10 down to seven. And so Court got down to 9, got down to 8, and then Johnson's term was up. And once Johnson was no longer president, Congress set the size of the court at 9 justices, where it has remained ever since.
That story was fascinating. I confess I didn't, I thought I knew presidential history pretty well, and I did not know that they had specifically cut the court down from 10 to 7, aimed squarely at Andrew Johnson. We tend to think the court being very politicized now and battling with the president, and there's so many things to talk about here. There's so many issues in the court's place in our world today. But before we get there, there's one thing in particular I want to ask you about, because there was a lot of attention paid to it at the time that it happened. You don't go out of your way to address this, but you address it nevertheless in several places in your book. We all remember in 2016 when Antonin Scalia died in February, and Mitch McConnell refused to even consider Barack Obama's nomination of Merrick Garland for the court, because he said there was precedent that a Senate held by the opposition party to the president in power was not obliged, had never happened, he said, to consider a nomination by a president in the last year of his office. And then, of course, we all remember in 2020 when Ruth Bader Ginsburg died, and 8 days before the election, they approved a new justice. You address this in your book, and it turns out McConnell did have history on his side. Whether or not he was right to do it or not, he certainly had history on his side. Can you talk about that a little bit?
Yeah, I mean, those sorts of shenanigans about trying to delaying domination kind of nominations or speeding them up, to get them in before presidential. That sort of stuff thing has been happening ever since the beginning. I will say probably the more common uh, uh, thing for the Senate to have done, rather than simply delay hearings for a year until there's a new president. Probably the more common thing that would to be done, which was done a fair amount in the 19th century, would have been go ahead and hold the hearings and then just vote no. Just
Right.
decline
Hmm.
to approve the president's nominee, and then the clock runs out. And then a different party gets the presidency. But yeah, this sort of thing is, I mean, it's probably unfortunate, but this has been par for the course for 200 years.
Hmm. Yeah, and you make a point to say it happened many times in the 19th century,
Yeah.
and just the way it played out in 2016. Let's go all the way back to the beginning. What did the founders envision when they set up this branch of government? You make a point of saying, I mean, your title is the most powerful court in the world. I don't think I'm wrong in saying there was no colonial equivalent here. What was their model for doing this? What were they thinking? And the third part of that question is, did it play out in the way that the founders may have envisioned that it would, all the way up to the present day, if we will?
Yeah, so there was no kind of 13 colony-wide court back then. And I mean, the extent, the closest equivalent would have been just the imperial government in England, which could in principle could decide things, but given the distances in practice, there wasn't a whole lot of that. And then under the Articles of Confederation, so between 1776 and 1789, there was no equivalent to the Supreme Court. So they knew the folks who wrote the Constitution. Yeah, they knew that this was something new, and this was actually one of the few things at the Constitutional Convention where people were unanimous about that everyone agreed. There had to be a single nationwide Supreme Court. They disagreed a lot about what the court would be like, and so the details there was a lot of debate about. But the existence of a single Supreme Court, because the alternative would have been 13 separate state Supreme Courts who could have all decided things differently, and then there would have been no one to resolve, who was going to win. And that was part of the reason. Another part of the reason for creating a Supreme Court was that there was a lot of worry that what if there was litigation between residents of different states? Each side would think that their opponents home state would be unfair to them, And so that was another reason for having a Supreme Court. Also, already, during the pre-constitutional period, there had already been disputes between the states themselves about boundaries, and so there needed to be some court that would be able to decide disputes between states. Oh, and then also, I mean, of course, the Constitution itself um, has all sorts of limits on what the federal government's allowed to do, limits on what state governments are allowed to do. Someone's got to be able to enforce those limits, right? Someone's going to be has to have the power to decide when the federal government or state government has done something the Constitution forbids it from doing. Again, that was going to be the Supreme Court. And so, people were fully aware that they were creating an institution that really had no parallel in any other country. This was going to be a court that was going to be extremely powerful.
Did they envision from the beginning that this court would have the power to strike down federal legislation passed by the people's representatives?
Yeah, no, definitely. I mean, that was understood. That was part of the design. Also state legislation, passed by state legislatures. That was the power. This lawyers call this the power of judicial review, and this was understood from the beginning.
One of the things that's not in the Constitution is any enforcement mechanism. And this has become an issue. It is currently an issue. We, in this country right now, are having conversations about what happens if the court hands down a decision, not just the Supreme Court, but any court, and the executive branch decides to simply set it aside and pay no attention to it. Did the founders foresee anything like that happening? And maybe take us through when there have been some flashpoints in our history, right? When there were moments when people didn't quite know if not only the executive but the rest of the country was going to abide by a decision.
Yeah, this has been an issue since the beginning, right? Because I mean, this is why Alexander Hamilton famously called the judiciary the least dangerous branch, because the judiciary, they don't have an army, they don't have a police force. They can't enforce their decisions. All they can do is write words on paper and hope that people listen to them. And so this was the sort of there's from the beginning, people realized this is going to be an issue. Are people going to follow what the Supreme Court says? Particularly in the early years, the issue was, are state governments going to abide by decisions of the Supreme Court? And if a state thumbs its nose at the Supreme Court, what's going to happen? And there were issues. There were some episodes in the. I guess all through the court's history, there have been episodes of states trying to not follow Supreme Court decisions. I mean, one very famous one from more recent times is, after the Supreme Court in Brown v. Board of Education said that segregated schools were unconstitutional. Of course, the southern states, they continued operating segregated schools for quite a long time after that, and were deliberately flouting the Brown decision. So this has been an issue constantly, and as you say, there's a lot of speculation these days about what the current administration will do confronted with a Supreme Court decision that it doesn't like.
Have there ever been cases where the president simply set aside a decision or refused to abide by it, even though they are charged with executing the laws?
Well, yes and no. It's hard because depends on some of these episodes. You can describe them in more than one way, and so there's a famous example in when Andrew Jackson was president, and the court decided a case called Worcester v. Georgia. Well, it's a Georgia case, I'm sure you know about it, where the court held that basically Georgia was basically trying to kick the Cherokees out of Georgia by making life extremely difficult for them, and the court told them they had to stop. I'm oversimplifying greatly here, and there's a famous quote that's probably apocryphal, where Andrew Jackson says, "Well, John Marshall has made his decision. Now let him enforce it," because there really wasn't anything for the federal government to enforce. But life didn't get any better for the Cherokees, I would say, in Georgia, and the federal government removed them out of Georgia several years later. So, I mean,
Hmm.
that's one famous example. Trying to think what would be.
We'll
Oh,
talk about.
yeah,
Go
so
ahead.
I'll tell you one that very nearly happened. That very nearly happened, which was during the Depression when Franklin Roosevelt
Yeah, I was
was.
going to ask you about that. Hmm.
Yeah, yeah. So the government, the Roosevelt administration said that gold clauses, like contracts that required payment in gold, could no longer be enforced. They would only be you could only have to pay in dollars. And it was close call as to whether the Supreme Court was going to uphold that. And Roosevelt had actually had a speech prepared in which, if the court had struck that down, he was going to announce that the administration was going to disregard the court's decision. And as it ended up happening, the court upheld it, and so he didn't have to deliver that speech.
And it goes without saying that if presidents set aside Supreme Court decisions or decide not to abide by them, that's a very dangerous precedent going down the road because every president of different parties can pick and choose and cherry pick which our vice president currently has said that the courts or that politicians can do that. And of course, some blue states said, well, then we had the right to leave a president's name off of our ballot, even though the Supreme Court said we couldn't. When they were talking about Trump and the 14th Amendment. So let's go back to the beginning because we have a very clear idea, I think, of the role we think the Supreme Court plays in modern American life, political, social, and economic. That the court is in some ways an arbiter of modern American rights. There was a court argued yesterday as to whether a straight woman could sue for discrimination who lost her job. She said to a homosexual male, another white person, but someone who was hired explicitly because of their homosexuality. And so we sort of see the court now as the arbiter of American rights, protecting them or protecting perhaps government or protecting the weak over the powerful or the powerful over the weak. But that is not really the way the court existed through most of the 19th and even the early 20th century. So I know that's a long sweep of history I'm asking you to talk about, but kind of describe for our listeners what the court did during most of those years.
Yeah, so our current emphasis on individual rights is really a 20th century phenomenon. I mean, this is a story that's much broader than just the Supreme Court. It's basically American society. We're very conscious of individual rights now, but that really only started in the first half of the 20th century. Yeah, so for the court's big cases so before the Civil War, certainly the court's big cases tended to be about the relative powers of the state and federal governments. What sorts of things could state governments do? What sorts of things were reserved for the federal government? That sort of thing. Now that affected people's lives a whole lot, but it wasn't spoken of as being individual rights. Rather, it had to do with the powers of units of government. Right. After the Civil War in the late 1800s, a lot of the court's big decisions involved protecting economic rights, involved protecting the rights of businesses or individuals conducting business to be free of government regulation. And I guess you could call that's an individual right. And so to that extent, the court in the second half of the 19th century, early 20th century, was involved in individual rights, but it's not the sorts of rights that tend to make the headlines today when the Supreme Court hears cases. So things like issues like the freedom of speech really only became big deal at the court in the 1930s or so. Race discrimination only became a big deal at the court really in the late 30s and the 40s. The rights of criminal defendants, constitutional rights of criminal defendants, so things like like the right to counsel or the famous Miranda warnings, things like that. That's the 1960s. So yeah, I mean, over the long haul, the composition of the court's docket has changed a lot, and it's really reflected changes in American society. It's like what people think is important.
Hmm. You also make clear that as the years have gone by, the court has uh, not only changed in terms of its number, but also in terms of the kinds of cases it listens to. This was sort of really fascinating to go through your book at various times. It always seemed like the court was overworked. On all the years they had to go out on the circuit, they literally had to ride over some usually horrific roads through most of the 18th and 19th century, which is one reason this was not a very particularly appealing job. I know that both Washington and Adams, the first two presidents, had a hard time filling positions, which nowadays we would think that's incredible. But in part it was because of the onerous workload that the Supreme Court justices had, and even through, and we'll get to the 1920s in the 1925 Judicial Reform Act with William Howard Taft, the court couldn't just decide what kind of cases they were going to listen to, right?
So that's right. So today's court um, uh, doesn't, they decide for themselves which cases they're going to hear, and so they only hear each year they only hear about 1% of the cases that are presented to it. And as you say, that's an innovation that got started in the 1920s. Before that, the court had to hear every case that came to it, and so most of the cases that the Supreme Court decided were of no conceivable interest to anyone other than the litigants. They were just these really routine cases involving, breaches of a contract or accidents or, things like that, things that the sorts of issues that the Supreme Court would never decide today. And so there were so many of them that the court typically decided them unanimously because there just wasn't enough time for anyone to write dissenting opinions. And they would write very short opinions. People who are familiar with Supreme Court opinions today know that they go on forever. They could be 50 pages long. But typical Supreme Court opinions before the mid 20th century were, just a couple of pages. They were very short. Yeah, so that was a big change when the court gained the power to decline to hear cases. That was a big change.
And they rode circuit until when? The 1890s, I think.
Yeah, so their circuit riding responsibilities were greatly reduced in the 1860s, and then eliminated in the 1890s.
Hmm.
Yeah.
So what did happen in the 1920s? You mentioned that there were three specific things that happened. You call the birth of the modern court. We can date it to the 1920s. Take us through that. What were those?
Okay, so one thing was what we've been talking about. So in the Judiciary Act of 1925, the Supreme Court got the power to decide for itself what cases it would hear, and that was the brainchild of William Howard Taft, who, of course, had been president, but at this time was the Chief Justice of the Supreme Court. And the idea was, I mean, Taft was the kind of the main mover in this, but it wasn't just solely his idea. It was an idea very much in the legal culture at the time. The idea was rather than having the Supreme Court just decide, you know, all these cases, let the court focus on just the important ones. That the court's role shouldn't be to correct errors of lower courts, but rather the job of the court should be to define what the law was in important matters, matters that would affect a lot of people, rather than the sort of insignificant cases that it was hearing before. And so that's one big thing that happened. That was 1925, and that set in motion all sorts of other changes. The nature of the way people conceive of the court had changed as a result of that. So before 1925, the Supreme Court was just, it was a court. It decided cases. It just resolved disputes between litigants. After 1925, it took a while to develop, but certainly within a couple decades after that, the court was no longer just another court. It was a lawmaking institution. It was an institution that would survey all the litigation that was going on, that was presented to it, pick the issues that it wanted to talk about, and talk about them, and make law about them. So it really changed the way people perceive the court. Okay, so that was one change that happened. Another change that happened in the starting in the 20s was the court got its own building. So before then, the court the court had a room in the Capitol building, and but that was just a courtroom. There were no offices for the justices. They worked at their homes. They were like the original remote workers, the Supreme Court justices, and uh, uh, it wouldn't have made sense to even have a building that in the early years when they were spending most of their time riding circuit, they were only in Washington for a couple months out of the year,
Hmm.
and so they didn't even have homes in Washington. The justice they didn't typically didn't bring their families. They would live in a all together in a boarding house. And they'd eat dinner together. They talk about the cases together. Uh, uh, so anyway, so there was no building until again, this was Taft was the ringleader of this as Chief Justice. He thought that and the court should have a building. This again, he's not the only one. There have been proposals to build a courthouse for the Supreme Court for decades before that that had just never come to anything. But it was Taft who managed to get the legislation in Congress to build a building. So that's the current Supreme Court building, which was construction started in the late 20s and it opened up in the early 30s. So that's another change. And then the third change that took place right around the same time is this something we were talking about earlier. This was the period when the court started deciding more and more cases involving individual rights. So, freedom of speech, freedom from discrimination, freedom from rights to exercise of religion, those sorts of things, which were not a major part of the court's caseload before the 20s. That the 20s is when that process got started. And again, this is just the start. It took a while to develop, but you can really date the origin of that to the 1920s as well. So that's why I say in that chapter that if you combine those three things, the ability to decide which cases they're going to hear, the new building, and then the change in the composition of the cases, the old court kind of turned into the court that we're familiar with now.
And the new building is really important because it did change the way the judges interacted with each other as well, right?
Yeah, no, that's right. So they didn't, back in the day, they used to work in their own homes, uh,
Hmm.
and now they all work in the same building, so they see each other a lot more. Also, it changed the building changed the way that the court is presented to the public. So it used to be that they had a little room in the court had a little room in the Capitol. Uh, that's all they had. They didn't, so the public, members of the public could see them like, walk in, put their robes on, walk onto the bench. There was no like theatrical component to it. It was just very ordinary. You know,
Hmm.
now the Supreme Court was deliberately the building, the Supreme Court building was deliberately designed so that the public never sees the justices except when they come onto the bench from behind a curtain. It's like almost
Hmm.
like they're dropping down from the sky or something. So the public, the justices they drive in their cars, they park in the basement and underneath they come up and the parts of the building where the justices and the law clerks and the secretaries and so on, where they all work, is off limits to the public. And so the public never sees the justices except when they're on display, when they're wearing their robes and they're hearing cases. And so it kind of gives it's I don't know, it's like the Wizard of Oz or something. Like it gives them this sort of like awe-inspiring look that was completely absent before the court.
Hmm. Hmm.
Like I say, the Cass Gilbert, who was the architect who designed the Supreme Court building, deliberately designed it this way.
Hmm. And to those listening, if you've never seen the chambers of these justices, it's worth going online or finding. You can find some really good coffee table books about the Supreme Court. They're really nice. They all have fireplaces, wood
Yeah.
burning fireplaces. They're just beautiful chambers, a nice place to work. It's interesting that you mentioned things like freedom of speech. I mean, one of the things that I want to make clear that a history like yours does is we tend to think that the Constitution has a Bill of Rights, freedom of speech, freedom of religion, the kinds of things that we've grown accustomed to. You make it clear in your history, and again, it's not a history necessarily of cases, but you make it clear that the court used to interpret the Bill of Rights as applying only to people and their relationship to the federal government. That states did have the right to curb freedom of speech or freedom of religion or search and seizure. All of those things were sort of 20th century inventions. It wasn't until the 20th century that the court interpreted the Bill of Rights to apply to state governments as well. And I think that's kind of a revelation to a lot of people.
Yeah, I mean, let me say though, I think you're combining two different things there. So yes, it's true that the Bill of Rights in the U.S. Constitution only limited the federal government up until the early 20th century, and that if you literally it says Congress, each of the first 10 amendments, or well, most of the first 10 amendments are worded like this: Congress shall make no law, blah blah blah. That was taken literally. So yes, that's true. On the other hand, virtually every state constitution has its own Bill of Rights that
Mm.
limits the state government. And so when people would want to complain about, want to litigate about something a state government had done, then would use the state constitution, in the parallel clauses of the state constitution. And I mean, and those, of course, those state constitutions still exist today, and people often invoke state constitutional rights still today. So that's one thing, is the state versus federal. But even apart from that, our whole notion of individual rights is a 20th century phenomenon. So even though people in the 1800s could have used state constitutions to argue about the freedom of speech or freedom from searches and seizures and so on, they very rarely did. People just didn't think that way, you know?
Hmm. Hmm.
So like I said, there's two different things going on there.
Yeah. One of the cases I know with freedom of speech that you write about in your book is a Colorado journalist who had written an editorial when he came out against the Colorado Supreme Court justices. And the Supreme Court of the United States found that he was being prosecuted for that. He claimed an abridgment of First Amendment rights, and the court didn't agree with him and said the First Amendment really only means you can't be censored before you say something. After you say it, there may be consequences, and that's what's happened here. That's all changed, has it not?
Right, and that changed in the first half of the 20th century, right, to the idea we have now, which is the First Amendment. It's not just about pre-publication censorship, but it's also about it's also about not punishing people for the things that they say.
Hmm.
Yeah.
And before we get to the mid 20th century, because that's really, I think, where the really, and I'm not, I was going to say the really exciting stuff begins, where the controversial things begin. But
Well,
is it?
things that are controversial now. I mean, the
Yeah.
things in the 1800s, they were controversial in the 1800s. They're just not
Yes.
controversial anymore. A typical best example, slavery. Slavery was enormously controversial in the 1800s. It's not
Hmm.
very controversial anymore. You don't find too many defenders of slavery.
Hmm.
But, that was these were huge deals back when
Yeah.
they were controversial.
Oh,
Yeah.
absolutely. Yeah. And what I was going to say is that it may be an overstatement, but really until the middle, or at least the first, starting in the 1930s, as you said, the court almost always found in favor of the powerful over the weak, in the sense that they did not, they tended to expand the power of government in some ways, or say that, for instance, in the famous Cruikshank case in 1876, that the 15th Amendment did not really give, and that was the amendment, of course, passed during Reconstruction, that was designed to ensure that African American men could vote. And what they decided in Cruikshank in 1876 was this 15th Amendment doesn't give anyone the right to vote, which would seem in direct contradiction to what the amendment was designed to do. And there
Yeah.
seem to be a lot of cases like that.
There were a lot. So in the late 1800s, early 1900s, the court in cases involving race discrimination, the court virtually always decided in favor of the discriminator. So it was the court did. So you can divide the cases into two buckets, right? And so in one bucket, the court greatly restricted the ability of the federal government to do anything about discrimination. These were mostly, at the time, it was mostly in the South. Greatly, sharply limited the ability of the federal government to do anything about it. But then also, when Southern state governments started passing discriminatory legislation, Supreme Court upheld that, said that was just fine. And yeah, certainly by modern standards, the court had an atrocious record on civil rights. late 1800s and early 1900s. Although, to be fair, that was majority white opinion nationwide. I
Hmm.
mean,
Hmm.
the justices, they were just people drawn, people of their times, and I think that these cases would be hugely these decisions they'd be hugely unpopular today, but they were not hugely unpopular at the
Hmm.
time. And that would just seem like common sense at the time.
Well, and often what they would say is the federal government can't keep someone from voting because of their race, but states can. And besides that, nothing in these laws say it's because of their race. And so we don't know what the intention was. Therefore, it's not unconstitutional. And you make clear that in the few cases, like blacks sitting on juries in the first decade of the 20th century, when they found in favor of blacks sitting on juries, it didn't do any good, right? They couldn't do anything to enforce that in the South.
No, that's right. That's just that's another example of sort of thing we were talking about earlier. Is that the Supreme Court can say whatever it wants, but it requires enforcement on the ground. And
Mhm.
the southern states just came up with different ways of excluding black people from serving on juries.
And there have been many times throughout our history. 1954 was the most famous when the court decided something that so outraged people that Congress has said, we're going to pass laws to keep the Supreme Court from hearing cases about X. Or when they decide something, I want you to talk a little bit about some of these legislative proposals that they sound a little harebrained now, but they also, I think, go to the heart of the fact that when the Supreme Court makes a decision that can seem controversial and unpopular, that's when everybody hones in on the fact that you're talking about nine unelected people serving for life, kind of imposing their will from the bench on everyone else. And there have been obviously some famous, but even, for instance, when they said child labor, that the famous child labor case in 1918, I think that was Hammer versus Dagenhart. 1918, they said that the federal government did not have the power to prohibit child labor, and it was because it had something to do with production as opposed to commerce. And people said, okay, we're going to pass legislation to keep the Supreme Court from hearing cases about this. And that happened many times and still comes up.
Yeah, so the jurisdiction of the Supreme Court is defined by Congress. And so whenever the Supreme Court decides a case in a way that some people in Congress don't like, one obvious response is to propose legislation restricting the court's jurisdiction. So if you don't like the way the court is deciding cases in topic A, say, okay, the court's jurisdiction doesn't include cases in topic A. That has been a these proposals typically don't go anywhere. I mean, there's been hundreds of these over the years, from the early 1800s right up through today, and Norton they usually don't go anywhere. But yeah, that's been a constant. But I mean, or you raise interesting question, which is, this is basically the fundamental thing about the Supreme Court is it's nine elderly lawyers who serve for life and were not elected, and and whenever they decide a case in a way that people don't like, people start saying, well, wait a second, why is it that we give so much power to nine lawyers? Why should nine lawyers be the ones who are deciding these important questions? Of course, when the court decides cases the way people do like, they don't say that.
Mm-hmm.
They say, oh, well,
Mm-hmm.
it's just the wisdom of having a Supreme Court constituted this way.
So one way to deal with the court when a case came down you didn't like was to change their jurisdiction, and the other was to change the size of the court. And this goes back, of course, to the earliest days as well. We talked about it already a little bit that there's certainly precedent for decreasing the size of the court when you want to keep a president from being able to appoint someone, but usually it goes in the other direction. We hear let's make the court bigger. That famously happened in the 1930s, but as you point out toward the end of the book, Joe Biden entertained it as well. Nearly every president does who finds themselves, and the ways to do that have been varied through the years as well. Talk about some of those, if you will, and why they don't go anywhere either.
Yeah, so the most famous episode of that was, as you say, in the 30s when Franklin Roosevelt became president, and then 1933, 1934, all sorts of legislation to try to get the country out of the Depression, all sorts of new government programs. And in case after case, the Supreme Court struck them down, found them unconstitutional. And uh, so the Roosevelt administration gets frustrated when Roosevelt is reelected in 1936 by a landslide, an enormous margin of victory, and the Democrats get big majorities in both houses of Congress. So the Supreme Court, at that time a very conservative Supreme Court, was the only obstacle preventing the implementation of these New Deal programs. And so Roosevelt announces that basically they're going to expand the size of the court, and the stated rationale for it, which everyone knew was not really the case, was that the justices were old and they were too old to do all their work. They needed help, and so the way it was set up was that a new justice would be appointed for each justice who is over the age of 70 and doesn't retire. And given the composition of the court at the time, that would have allowed, if that had been passed by Congress, that would have allowed Roosevelt to appoint 6 new justices right away. Would have expanded the court from 9 to 15. Now, this plan was not very popular. I mean, even among Democrats, it was not very popular. And the reason was, it just seemed so blatantly like an attempt to grab political power. And at the time, remember at the time too, so this is in the mid 30s. Just within the last previous few years, Hitler had done something similar with the courts in Germany, basically, taking control of the courts in Germany, Mussolini in Italy, Soviet Union. I mean, the idea of politicizing the courts this way, it just struck a lot of people as wrong. And so this plan, it was never very popular. And then, as it turned out, it turned out not to be necessary, because the Supreme Court eventually started approving New Deal programs, stopped striking them down, and so there was no longer any need to pack the court. And so it ended up being rejected by the plan ended up being rejected by Congress. But at that point, it was the Roosevelt administration. It was no longer any useful for the Roosevelt administration at that point. Anyway, so that was the 30s, and that was 1937. And then for many years thereafter, the idea of packing the court, of expanding the court because you don't like the justices' decisions, the idea of packing the court, it kind of fell into disfavor. Like there were not for a long time afterwards. There were not serious proposals to pack the court until relatively recently, right? So until the recent Supreme Court, of course, is very conservative, probably more conservative than the country as a whole. And so among Democrats, in recent years, there's been discussion. There was discussion about packing the court, although of course it didn't happen.
And I've had discussions with people I've read where, if Mitch McConnell had needed to put 87 justices on the bench in order to get a conservative majority, he would have done that. Sometimes it's hard to argue against that.
Yeah, I mean, that's one of the standard arguments against expanding the court for political reasons, is that of course, if one party does it, say, let's say that under Biden, let's say the Democrats had expanded 9 to 11. Of course, then next time there's a Republican president, they're going to go from 11 to 15, and then the Democrats should go from 15 to 23, and so it's going to be crazy.
Yeah, exactly. And so it's been its current size since, I think you said 1869. That's where it's been,
that's right.
And that's where it's probably liable to stay.
Yeah.
And so let's talk about some of the most famous cases the court has ever decided have been the ones in retrospect that were the most not just controversial, but considered in retrospect to be just wrong, decided the wrong way. We know all about Dred Scott versus Sanford in 1857. We know about Plessy versus Ferguson in 1896, because they were probably the two most famous. But there's a couple of others that I want you to talk about. One is the famous Lochner case. I think it was Lochner versus New York in 1905. Still talked about was brought up recently, even during some of the cases I think that the court decided in the last 20 years. What happened in the Lochner case, and why is it so odious?
Yeah, so the Lochner case has come to kind of stand for this whole bunch of cases in the late 1800s, early 1900s, in which the court struck down economic regulation as unconstitutional. So the Lochner case itself, involved a New York state law that limited the working hours of bakers, of bakery employees, right? And the idea was that working in a bakery is unhealthy, I guess breathing a lot of flour and so on. And so it was to limit, and I forget exactly what the details was, but by modern standards, it wasn't much of a limit. It was something like only 12 hours a day
Right.
or
Yeah.
something like that.
Hmm.
Um, and so the court struck it down as unconstitutional. And the rationale for these sorts of cases was, and this is a rationale that people no longer believe in, but it was commonly believed in at the time, was that the idea was that the government shouldn't has no business like playing favorites, right? The government's only job is to enact legislation that's for the public good, and the government cannot enact legislation whose primary purpose is just to help group A at the expense of group B, right? Or to transfer resources from group A to group B, or something like that. Like that was unconstitutional. That was the idea. And so the debate in Lochner, I mean, Lochner was a 5-4 decision. The debate in Lochner was, okay, was this really a measure for the health of bakers, or was it, class legislation? Was it the transfer? Was it that the bakery employees, they just wanted to work less, and they couldn't get that in negotiations with the bakers, so they got the state to do it for them, to basically transfer power from the owners of bakeries to the employees who worked in bakeries. Now, of course, today we would say, of course, that's a normal thing for legislation to do, right? So we're familiar with, it's very common to have, minimum wage legislation, maximum hour legislation, all sorts of legislations intended to protect the weak and from the strong, right? To transfer power from the strong to the weak, from one group to another. But, according to the conventional legal thought of the late 1800s and early 1900s, that was off limits. That was the sort of thing that was unconstitutional. Anyway, so Lochner was just one of a zillion cases that were decided in that period that basically all came out that way. And but it's just kind of a coincidence that or fluke that this one case came to stand for the whole. And so these days, among constitutional lawyers, if you say Lochner, that's like it's like a bad thing that the Supreme Court did in the past that we should never do again.
Like Dred Scott. Yeah.
Fred Scott,
And you make the point that for a lot of people, Lochner epitomized the kinds of cases where when legislation was passed to help, the common worker, the individual against the behemoth corporation, the Supreme Court always found in favor of the corporation.
not always, but
Yeah, not
often.
always, but it seemed like.
And here's an example. Here's an example. So right around the same time as Lochner. So Lochner invalidates a maximum hours wage
Hmm.
for bakers, and the theory of the majority is, no, the bakers don't. They don't. That's not for the public good. Bakers can stick up for themselves. Okay, so right around the same time, the court approves a maximum hours law for women, right? And then
Hmm.
the idea was, I mean, the rationale for the majority was, well, uh, a maximum hours law for women is in the public interest. It's not just a way to help women at the expense of their employers, because, at the time, the conventional view was that women were uniquely susceptible to the evils of overwork, and, how can they properly bear children and care for children if they're overworked and so on. I mean, there's
Hmm.
a bunch of attitudes that people don't hold to anymore. But, so that's an example of it wasn't as if the workers always lost these cases, but
Hmm.
they lost a lot of them, and the reason they lost was if they couldn't if the justices didn't think that this was regulation in the public interest, but was rather merely regulation intended to benefit employees at the expense of employers.
Yeah, and to bring up the the Hammer versus Degenhardt again on child labor. So much of what was going on here, of course, this was during the Industrial Revolution. And so this completely revolutionized the American economy with production versus labor. There was unionization. There was fear of socialism, which you make clear a lot of the justices hated socialism, feared redistribution of property and wealth. And so a lot of legislation was written to apply to the interstate commerce aspect of whatever was being produced. And so you could regulate child labor, let's say, or women or other things, conditions in the workplace by writing it very carefully about this was because of interstate commerce. And where the Supreme Court stepped in Hammer versus Degenhardt and said the federal government did not have, in this case, the power to prohibit child labor was because the things being produced in some of those cases were inherently bad. But child labor was producing garments, whatever. The things they produced that crossed state lines were not inherently bad. The production might have been inherently bad, but the commerce itself wasn't. And this seemed like a technicality and the kind of thing, again, that people found just morally outrageous. But it kind of encapsulates for so many what the court was doing at that time.
Right. So the child labor case was right about the limits of the power of the federal government. So everyone agreed that the states could prohibit child labor if they wanted to, and most states did prohibit child labor. And but the child labor that still existed in the early 20th century was mostly in the South. You know, a lot of children worked in textile factories, particularly. And so the question was, could the federal government prohibit child labor? And the federal government's the Constitution says that Congress can regulate interstate commerce, right? And so the question is, so the you know these statutes were always written. I mean, they're still written this way. That that wasn't that child labor was prohibited, but rather that child, I forget exactly the wording that child labor affecting interstate commerce was prohibited, or something along those lines to fit within the Constitution's grant of power to Congress to regulate interstate commerce, right? And so at the time the Supreme Court maintained the Supreme Court policed that limit quite strictly, and so if something was not literally commerce, then it was understood to be outside the power of Congress. And so, yeah, the Supreme Court decided that that what Congress was really doing was prohibiting the labor itself and not the interstate commerce in the goods produced by the labor. So it was beyond Congress's power, right? And so that was a very unpopular decision. In fact, so unpopular that there was very nearly a constitutional amendment to authorize Congress to prohibit child labor afterwards to try to correct that. As it turned out, the Supreme Court would several years later ended up overruling it, allowing Congress to prohibit child labor, and so the push for the constitutional amendment fizzled out because it wasn't necessary anymore. But this was I mean this idea that the Supreme Court should police the limits of interstate commerce quite strictly. That you see that in lots of cases beyond just child labor. I'll just give one that I think is particularly interesting. That's why, to this day, baseball is the only sport exempt from antitrust laws from the federal Sherman Act, the antitrust statute, is because in a case from the 1920s, so right around the same time as the child labor case, Supreme Court said that baseball is not commerce.
Mm-hmm.
So Congress, lacks the power to apply the antitrust laws to baseball.
Mm-hmm. And something you said there, and I want to be mindful of your time. There's so much to talk about. We haven't even gotten to the liberal court yet. But real quickly, so much of what infuriates people about the Supreme Court is in regards to child labor. They can, and I'll make this up, in 1930, they can say something is unconstitutional, and 10 years later, under almost exactly the same circumstances, suddenly it is constitutional. We see the same thing happening now. There's no longer, is there really a right to privacy in the Constitution, or isn't there? And we all know it all comes down to the ideological makeup of the court, interpreting what is and what is not constitutional. And what do we do with that, and where does that go? Or is that just something we have to live with in this country?
It's something we have to live with. It's always been true. And if you've ever tried to interpret the words of the Constitution and apply them to particular situations, you will know that most things, I mean, the Constitution is quite short. It's in quite general terms. There's often arguments on both sides. And so, it's not at all unusual for the court to overrule itself and decide a case differently, right? These days, of course, the most famous examples with abortion, with the overruling of Roe v. Wade, but there were examples of that in the 1800s too. It seems to me that is an inevitable feature of a system in which you have a high court that's got the final word on what the Constitution means. It's hard to imagine how things could be otherwise. Because you wouldn't want to have a rule that the Supreme Court could never overrule its prior decisions, right? Because then we never would have had, we still have Plessy v. Ferguson, right?
Right.
It could never have been overruled in Brown.
Yeah. And you make it clear that these things do come in cycles. Obviously, so the most liberal the court ever was 1954 to about the mid 1970s. The Warren Court and the Burger Court to some extent. This is when, of course, the most famous cases were handed down that ended segregation, that found a right to privacy and therefore a right to an abortion. And of course, the Miranda rights, the rights that criminal defendants have when they are charged with a crime, the right of the government to break in or kick the door down of your house and to without a warrant, and to find incriminating evidence, and that being thrown out. These were enormously controversial decisions in their time, but they were also hailed as landmarks because they expanded the whole notion of personal freedom. And in some ways, the court over the last 20 years has been designed to overturn or at least radically circumscribe those rights. Is that correct?
Well, yeah, I mean, the court for almost its entire history has been to the right of the public generally. Now, this is hard to say. In the very early years, it's hard to say what's right and what's left, and so it's hard. Our modern political terms don't easily translate to the very early cases, but certainly since the Civil War, the court has been almost all the time more conservative than the public generally, with the exception, as you say, for a couple decades in the middle of the 20th century. And so there are all these famous liberal decisions from between the 50s and between the mid 50s and the mid 70s. And since then, of course, that ended. That was 50 years ago, and that ended. And since then, the court's kind of reverted to form. It's been back to its usual conservative self, but so much of it's very fluky. I mean, it depends first of all on which party wins presidential elections, and then with the fluky part is it depends on whether justices die or retire at particular times when a particular party has the presidency. And so the origin of the modern conservative Supreme Court is that Jimmy Carter is the only president to serve a full term without the opportunity to appoint a Supreme Court justice, which meant that Republicans appointed 10 consecutive justices between 1969 and I guess it would be 1991 or 1992. So for more than 20 years, a run of I think it's 10 straight justices, and that's what tipped the court from more liberal than the country to more conservative than the country, and it's been that way ever since. But that's the way it's set up. I mean, it's fluky in the sense too that if I mean, this is kind of a grim way to express it, but if Justice Scalia had died a little bit earlier, then that would probably have tipped one seat on the court. And if Ruth Bader Ginsburg had lived a little bit longer, that would have tipped another seat on the Supreme Court. And so we've currently got a 6-3 Republican majority. We have a 5-4 Democratic majority. If just the timing of two deaths had been off by a few months, it's a very fluky system. I will say that is one reason why there's been a lot of calls to change this, abolish life tenure. And so rather than having the appointment of a new justice depend on the fluky timing of when a sitting justice dies, have a fixed term, have them serve for a certain number of years, which most countries do that, and
Hmm.
that would also take care of the problem. Every so often, it happens that justices, they basically get senile, and before they retire. And not any of the current batch, I don't think, but it's happened in the past. And that I think that would be a good idea. It's just very hard to do because life tenure is baked into the Constitution. You'd have to amend the Constitution to do it. And at any given time, half the country loves the current justices, And so you need a supermajority to amend the Constitution, and it's just very hard to do that.
Hmm. How cognizant of public opinion should the court be, or does that matter at all? I mean, they are. I think we all know
Well,
that,
I
but
mean, they're human beings. They read the newspapers and watch television. They're online. They're just like everybody else. So of course they have to know about public opinion. You wouldn't want them deciding cases based on public opinion. I mean,
hmm
a lot of the issues that they decide involve, constitutional rights of unpopular people, and so the rights of criminal defendants. If you said if you ever and you never a criminal conviction is reversed because the defendant's constitutional rights are violated. That's very unpopular. You're a criminal. Why are you reversing their conviction?
hmm
Or think of very unpopular speakers. They have First Amendment rights too, and so you wouldn't want the justices to be considering the popularity of a decision. I mean, I think what you would want would be for them to genuinely try to discern what the Constitution requires, but
hmm
I don't know.
So, see if you agree with this proposition that I'm going to make, because one of the things you make clear throughout the book and in everything I've read about this book in public media is that the court has always been seen as political. There have been political appointments. Presidents and Supreme Court justices have always been chummy in some ways. They talk to each other on the phone. And you make a point of saying some presidents were given political counsel by sitting Supreme Court justices. Some justices worked with legislatures to craft legislation. But one of the things I think that has made the Supreme Court different now in the world in which we live is because of the era we just described, because they seem to be the arbiter of individual rights, right? There is a fear right now in the gay community that this court will reverse its decision on gay marriage, for instance, which would enormously change the lives of a lot of people. That they sort of hold the fate of a lot of people in their hands, perhaps in a way, in a very public way, that they didn't before. Isn't that new in the world in terms of the court and how it's
Well,
perceived in the public
yeah,
arena?
I mean, the sorts of issues that come before the court change over time, right? So the notion of this, that the Supreme Court would say that there's a constitutional right to same-sex marriage, that would have been inconceivable
Mm-hmm.
until recent times, right? And
Mm-hmm.
so the kinds of issues that come before the court change over time. But the notion of that the Supreme Court is the last word on people's rights, I mean, that was true in Dred Scott in the
Mm-hmm.
1890s. That was true in the court's cases upholding discrimination in the 1880s and 1890s. I mean, that's been true for a very long time. Now, the kinds of issues, the specific issues that we're talking about change, but the general idea that the Supreme Court is the last word on people's rights, that really isn't new. That really isn't.
Mm-hmm. Mm-hmm. And you say court opinions rarely, if ever, settle political controversies. They merely provide more material for the disputants to fight over. And what immediately came to mind was, and I think this happened after you probably went to press, was the opinion last summer of the court that presidents have virtual immunity for things they do while they are in office. Do you think that case will go like so many others? And I forgot to ask you about Buck versus Bell, but like Lochner and Plessy, that here's a case where they were asked to decide X, and they not only decided that, but they went far beyond it to decide something nobody really asked them about, and that's going to become a political football in and of itself.
No, it sure is, and it'll be interesting to see. It'll be interesting to see what that means in practice. And I mean, obviously it's too early to know now how that case is going to be interpreted in subsequent disputes. A lot of it's going to depend on who the personnel of the court and when those subsequent disputes get to the court. But you're right. I mean, that's just one more controversial decision in
Hmm.
It's now more than 200 years of them.
Did that decision surprise you, the law professor who's writing this book, when you heard it? Or did you go, no, this is right in keeping with what I would have expected. This is a conservative court.
Yeah, it surprised me. It did surprise me. It surprised me and how much protection they gave to the president for
Mm-hmm.
how much
Mm-hmm.
although but the I'm not sure that if you actually read the opinion closely, I'm not sure that the kind of the public media accounts of it actually describe it well, because what most of the opinion says is, here's a few very general principles, but come back to us when we have
Mm-hmm.
a more concrete dispute, and we'll decide whether it falls on this side of the line or that side of the line. So they did leave themselves a lot of leeway to decide, well, no, you're not immune for that, or you are immune for that, and it's all gonna depend on how it's implemented.
And the last thing I want to ask you about, and I don't mean to put you on the spot, but of course, one of the hot button issue right now, of course, is birthright citizenship. What is going to happen? I think we all know where that's eventually going to land. It's going to land in the Supreme Court. And if you read the 14th Amendment, it seems pretty straightforward, but you make it clear in this book that there are plenty of things that seem straightforward that the justices have said, oh, sorry, but you're not supposed to literally read that into the Constitution. Famously, of course, that was, I think, the case in the Crookshank, that 15th Amendment didn't give anybody the right to vote. Would you be surprised if this court, being conservative, agreed with the president that there isn't a birthright citizenship?
I would be surprised. This one to me doesn't seem like a close call, right?
Mm.
This one seems like the I mean, the idea of birthright citizenship is so. First of all, as you say, it's what the Constitution literally says. It's been how it's been interpreted ever since. I mean, it's only relatively recently that really there's been any disagreement, and
And it
even
was decided in 1898, was it not?
yeah.
Right, in the famous case,
By
right?
a very conservative Supreme Court that, as we were saying before, allowed all sorts of discriminatory things
Mm-hmm.
on. Even this Supreme Court would surprise me
Mm.
if it overruled birthright citizenship. But you're right to say we've been surprised before, so we will be surprised again.
Well, and one of the things you make clear that I have to say, you say, I think, that for most of its history, the court has been fairly conservative. There's only been a very few times when it wasn't right of center, and probably right of most of the population, but that those other times were really aberrations, and so we should not be surprised when they land on a more conservative position, maybe. And so it certainly makes sense of the world. Well, listen, I want to be mindful of your time. Stuart Banner, thank you so much for coming on. The book is entitled The Most Powerful Court in the World, A History of the Supreme Court of the United States. It was published in November by Oxford University Press. The author is Stuart Banner. Thank you so much for joining us, and continued good luck with this and all your other projects.
Okay, thanks very much.
My thanks to Stuart Banner for joining me on this podcast. You can find out more about his book at globaloup.com. The hardest working producer and engineer in show business, the producer of this podcast, the czar of our Tallahassee office, as well as the captain of the Off the Beaten Path three-sided football team, is our very own and indispensable Brendan Cannonball Crellin. All guest accommodations on Off the Beaten Path provided by the Horseshoe Road Inn. Our Off the Beaten Path fact checker is Ella Fino. The Director of Accounts Payable is Bill Schroeder. Our Director of Employee Loyalty is Upton Leftus. Our Staff Layoff Specialist is Harry Verderci, assisted by Layoff Counselor Oscar LaVista. The Off the Beaten Path Complaint Calls Specialist is Levon Hold. Our Daylight Savings Time Manager is Conrad Adenauer. Our Audience Data Collector is Paul Murky of Murky Research, assisted by statistician Marge Genovera. Our Russian chauffeur is Pickup and Drop-Off. Our financial advisor is provided by the firm of Ill-Gotten Gains. Our staff bus driver is Borden Drowsy. Our in-house literary critic is Al Ligori. The holiday wardrobe consultant is Don Wienow. Our staff director of Three Stooges Studies is Lee Iopoka. Dr. Todd Gross's personal eBay specialist is Selma Junkoff, and our Off the Beaten Path martini mixer,
Oh, thank you very much.
is Olive Twist. You can find our podcast anywhere you can find podcasts, including now on YouTube and YouTube Music. You can also find Off the Beaten Path on the podcast app on your phone, and I would ask you to please leave a review on the Apple Podcast app. That would be most appreciated and helpful. Be sure and like Off the Beaten Path on Facebook as well. Learn everything about the Georgia Historical Society at georgiahistory.com and the Georgia History Festival at georgiahistoryfestival.org. Please also visit the official Off the Beaten Path website at deatonpath.georgiahistory.com and check out my videos, my blog, and similar equal justice under law podcasts like this one. Stay safe, stay strong. I'm Stan Deaton with the Georgia Historical Society. As always, thank you for listening.